Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Video number 1423. This time we are going to discuss a case law on the contempt. You may be knowing the Contempt of Court Act is a very simple act which was enacted in the year 1971 to punish the guilty advocates, the guilty contemners, the guilty government officers for their act of willful breach of the court orders. You know, there are civil contempts and criminal contempts also. Now we are discussing the civil contempt case. Two judges bench, Justice Lav Nageshwara Garu and B.R. Gawai, while disposing the contempt petition number 638 by 2017, you can read the case as V.Senthur, S-E-N-T-H-U-R, Senthur and another versus T.Vijaya Kumar, he is the Secretary of Tamilnadu Public Service Commission, and 8 others. Total 9 people of Tamilnadu state, all of them, most of them are IAS officers. On 19th January 2022, of course, Supreme Court cautioned them, warned them, ultimately they have closed the case when they expressed remorse, and they said that when they said that there is no willful disobedience, and when they said that they have to implement the policies of the state, all these things, these are quite common, as you know. Let us know what happened first. So, the petitioners V.Senthur and another, who are working in the Public Works Department, they approached the High Court by filing a writ petition. Ultimately, the matter was dragged to the Supreme Court to revise the seniority list. But the Tamil Nadu Public Service Commission, actually, the postings, of course, there is a difficulty also. They have revised the seniority not on the merit but based on the roster points. This the problem arose there. Anyway, when the matter came to the Supreme Court has given clear instructions on 22/1/2016, that is about 6 years back. They have given clear instructions to prepare the list basing on the merit, but it was not done. So after a long time, when they filed the contempt petition in the Supreme Court of India, then these people, they have actually implemented the orders on 1/10/2021 when action for contempt of court proceedings was initiated by the Supreme Court. So that case has been continuing. Ultimately, actually, the contempt against them was confirmed. Then on 19th, they appeared before the court. When the court asked them in person, they have to do, that is virtual. When the Supreme Court asked their deliberate intention in not implementing the orders of the Supreme Court, since they failed to carry out the orders of the Supreme Court given on 22/1/2016. Since they published another revised list not taking into merit of the people, the opponents. Therefore, the court was of opinion that they disobeyed the court orders, therefore contempt action was taken against them. Had they obliged or had they obeyed the orders of the Supreme Court and prepared the revised list, there is no necessity for the employees like their appellant like Senthur and others to move from pillar to post for implementing the orders of the Supreme Court. No doubt, in the initial stage, they approached right from the commissioner, secretary, all these people. Once again, even though Supreme Court has given the orders, they were not implemented. Once again, they have to move from Chennai to Hyderabad, Chennai to Delhi. It's a very, very costly affair. After all, they are also public servants. The appellants are also, no doubt, IAS officers. Not only these public works department people, they are also doing the same job. Both of them are public servants, and both of them have to implement the policies of the state, is it not? So, therefore, even though the Tamil Nadu Public Service Commission gave a notification in the year 1999, and when there were discrepancies, the court has to interfere, and when the court has given directions in 2016, they have to implement it. since they are not implemented, now these people have to approach the Supreme Court. They have to plea innocence, they have to plea sadness, they have to face sorry, they have to actually curry the displeasure of the Supreme Court. All these things happen. So ultimately they expressed sorry or they expressed remorse, and they said that there is no intention, it is not intentional or wanton violation, and it is not a willful disobedience. Ultimately taking into consideration of their service as public servants, since they have to follow the policies of the state, ultimately Supreme Court has shown concern towards them and let them off from the contempt charges. Please remember, in this connection I want to tell you, Section 12 of the Contempt of the Court Act says that the punishment for the contemptor cannot be more than 6 months, or the fine may not be more than 2,000 rupees also. But still, why it is so much less? Because all of them are government servants, maybe advocates, so all of them are allied persons. సో మన తెలుగులో చెప్పినట్టు మంచి మనిషికి ఒక మాట, మంచి గొడ్డుకో దెబ్బ అన్నట్టు. సో if they are given just punishment itself is enough, maybe 2 months, maybe 3 months. You know what happened in the case of Prashant Bhushan in his contempt case? He was imposed a fine of ₹1. At the same time, if he fails to pay that ₹1, he will not be able to practice in the Supreme Court for 3 years. Therefore, he has paid the fine. Itself is sufficient. So the punishment may not be heavy in contempt cases. So this is what I wanted to tell you in a contempt case, right? They have taken the example of Tamilnadu case. So many things will be happening. Contempt cases have become now a common feature in the courts. Right. Anyway, if you find time, please read the judgment and enrich your legal knowledge. You can see the case as V.Senthur&anr versus T.Vijaya Kumar IAS&8 others in contempt petition number 638/2017. Thank you very much.